Let's begin with this story where the leader of the proscribed indigenous people of Biafra, Nnamdi Kanu, says he is exploring his option in law in line with Section 17 of the Federal High Court Act and Section 174 of the Constitution to negotiate with the federal government on the terrorism charges against him. Mr. Kanu, who spoke exclusively to TVC News, made this known after the court had ordered him to file his statement of defense. Celestina Area has details.
Sir, are you seeking an out-of-court settlement with the federal government?
I can't seek what I didn't initiate. They are the ones that kidnapped me and brought me here. So it's whatever they say that will happen.
But your lawyer is trying to move Section 17 of the Federal High Court Act,
yes,
which calls for negotiation. Are you in line with that?
I reminded the judge of our powers.
I think it's the judge's powers. I don't think it's within his powers. It's for the judge to decide.
Lead counsel to Mr. Kanu, Aloy Ejimako, made this known in open court after he moved two applications brought before the court. Mr. Ejimako says if the applications are denied, they will move for the implementation of Section 19 of the Federal High Court Act. Justice Iyanku dismissed the application and held she could not overrule herself. Section 17 of the Federal High Court Act Mr. Kanu sought to rely on says, in any proceedings in the court may promote reconciliation among parties thereto and encourage and facilitate the amicable settlement thereof. Responding to this, the counsel to the federal government, Adegboyega Womolo, told the court that he had earlier informed the defendant that he does not have the powers to negotiate on behalf of the federal government. The fiat given to him does not empower him to negotiate. Justice Iyanku, on her part, told the defendant to explore the section before the AGF. Meanwhile, the court held that pending that outcome with the AGF, Mr. Kanu should file his statement of defense. The court adjourned to 24th September for hearing.
Shall be promoted by the court between parties before the court, criminal or civil. So it so happened, and it came to pass that today that very issue was briefly considered in open court.
The government has also adopted that same approach in the major issue where they filed discontinuance. They have also done it in Sowore issue where they filed discontinuance. And when we had all these issues in Niger Delta, there was reconciliation and discussions. When we had all these issues, even in Northeast, there was the same issue. North Central, there was the same issue. So how come we have gotten to the Southeast, then nobody is having this conversation?
The 147C of the Constitution empowers the Attorney General of the Federation to discontinue a case before judgment is delivered in a criminal proceedings instituted by him or any person or authority. Celestina Area, TVC News, Abuja.
Interesting development.